otherwise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Welcome to FCPA Flash. This is Professor Mike Kaler, and in today's episode, I'm pleased to have a conversation with Paul Calley. Mr. Calley has been a lawyer for 23 years and has spent his career in the courtroom trying cases. As a government lawyer for the first 7 years of his practice, Mr. Calley tried over 125 cases to verdict as lead counsel. And since entering private practice, Calley has managed to attract clients uninterested in striking deals and instead committed to exercising their constitutional right to trial and putting the government to its burden of proof. As a result, Calley's trial number now exceeds 150 cases to verdict. For the last 8 years, Calley and his partner, Chaz Short, at Calley Law, have partnered and been in trial and won a series of high-profile public corruption, fraud, and FCPA trials throughout the United States and its territories. And this includes the DOJ's, quote, landmark case, the so-called Africa Sting case. One of the major, really, failures in the DOJ's FCPA enforcement program over the last 7 years. Welcome, Paul.
Thank you for having me, Professor.
One of the reasons I wanted to talk to you today is you've really done something that few FCPA practitioners have done, as sort of suggested in the intro there. And that is, on behalf of your client, you've put the Department of Justice to its burden of proof in an FCPA case. Can you please tell listeners a bit more about the Africa Sting case you were involved in and the ultimate outcome?
Yes, the case was at the time a prominent piece of DOJ's aggressive effort to bring accusations under the Foreign Corrupt Practices Act after a several year-long undercover sting operation manufactured by the Department of Justice and the FBI. 22 business executives were arrested in the case where FBI agents posed as greedy, bribe-taking officials seeking to arm their tiny African nation with various military products and hardware. The defendants were all accused of paying $1.5 million in bribes to undercover agents who said the money would be used to bribe the Minister of Defense of Gabon, in part to win a $15 million larger contract to equip its presidential guard with military and law enforcement products. 3 executives pleaded guilty, but the government failed to secure any convictions of 10 others after 2 long trials. Ultimately, the first trial in the case of, I believe, 6 people resulted in a hung jury, and the second trial in which I was involved resulted in the acquittal of all 6 accused persons. Subsequently, the Department of Justice asked United States District Judge Richard Leon to dismiss all charges against every accused person, with the exception of the government's criminal partner, Richard Bistrong, who was the linchpin of the government's manufactured fake sting case.
Yeah, it was really a rather remarkable failure for the Department of Justice, not just because it involved 22 individuals, but Those 22 individuals were split into various trial groups, and as you mentioned, it was not just one but two hung juries. The jury acquitted several of the defendants, including your client. After the second mistrial, the foreperson of the Africa Sting jury wrote a guest post on FCPA Professor, basically calling out the Department of Justice and the FBI for acting in bad faith. And as you mentioned, very soon thereafter, the entire manufactured sting case, came to an end. When you really look at it, the Africa Sting case that you described was part of a relatively defined trend and not so much an outlier, because in the FCPA's modern era, more often than not, when the DOJ is put to its burden of proof, it often loses, often in rather dramatic ways, as highlighted in the Africa Sting case. What do you think accounts for the DOJ's rather dismal FCPA trial court record? And, to be fair, of course, I'm not suggesting, nor are you, that the DOJ has never won an FCPA trial. They have, but more often than not, they're really struggling when put to its burden of proof.
No, and of course the Africa Sting case and Lindsay Manufacturing and the others are not outliers. The outlier is, of course, the conviction that DOJ won in recent modern enforcement, which was the Haiti Teleco case, but in terms of the individuals convicted. But that's really the outlier. As far as the reasons for the sort of repetitive failures of at trial of DOJ, I think there's a bunch of reasons. First, obviously, there's a culture that DOJ, clearly promotes of self-report, settle, and plea. And it's odd because that the promotion of that culture occurs even though, as you said, the government just routinely can't prove its accusations beyond a reasonable doubt at trial. I don't know why there seems to be such a lack of an effort to put the government to its burden of proof. I know a lot of times in your presentations, either on the FCPAprofessor.com or in some of the speaking circuits where you appear, you've coined this phrase FCPA Inc., which refers to the practitioners in the defense bar, many of whom come from career positions as former prosecutors, often as supervisory officials in the fraud section working on FCPA cases. So, that could be one reason why the sort of modern enforcement program promoted by DOJ is really built on breaking companies down and sort of deputizing the lawyers who the companies engage into helping the government investigate and turn over information instead of fighting a case or promoting a defense in the case that may be a compliance issue.
Yeah, and you mentioned the Lindsay Manufacturing case, and just for listeners' benefit, this was another high-profile defeat for the DOJ in an FCPA case where, while technically the DOJ did secure a trial court conviction against two Lindsay executives as well as the company, that was overturned post-trial because the judge, a federal court judge in California, found numerous instances of prosecutorial misconduct that, in his words, led up to a prosecution that had severely gone awry. So you do see, as you indicated, several examples where it really raises the broader question of what does success mean when enforcing the FCPA. it sure seems like the Department of Justice measures success by the number of dollars its FCPA enforcement program is bringing in. But what do you think the struggles in individual cases when the DOJ actually needs to prove something? What do you think that says, or maybe doesn't say, and maybe they're just outliers about the success, quote unquote, of the DOJ's FCPA enforcement program?
Well, it's interesting to observe the reaction of the DOJ after it suffers these defeats, and I think tellingly after the Africa Sting losses and after the DOJ's loss in Lindsay and another case or two around that time, it feels like the DOJ, again with the exception of the outlier in the Haiti Teleco case, it feels like they've sort of, despite their rhetoric, have backed off of the individual prosecutions, at least, certainly to the extent they were trying to do it back in 2010, 2011. It gets back to the culture of cooperation and plea. I mean, if that's the paradigm, the lawyers in the FCPA fraud section just don't have a lot of trial experience, at least not in cases as complex and sophisticated as the FCPA cases. And so, it's a question of putting the case together and how it's executed at trial. On the other hand, particularly in the Africa Sting case, you would think where they manufactured the fake crime and they had 2, 3, or 4 years to prepare for a trial, that they would have had somewhat of a more cognizable approach to how they might prove their case, and I don't think that they did. Go ahead. I'm sorry, Professor.
No, it is rather concerning, from a practical standpoint, from a policy standpoint, when you consider that when the U.S. government marshals its full resources against an individual, that is going to change the individual's life. This is a real life with real family members, real reputations on the line. And in another one of the DOJ's trial court failures from a few years ago against John O'Shea in Texas, the trial court judge really scolded the DOJ and said, quote, well, you shouldn't indict people on stuff you can't prove. And, I'm not so sure what level of DOJ losses at trial is acceptable, but, it's one of those things you sort of know it when you see it. And, bringing criminal charges against an individual, as you well know, and working with your clients, is a life-changing experience for that person.
It is, and the Africa Sting case, again, you look and the agents and the prosecutors had coordinated with some prominent national media publications to sort of splash the front page on the day that they did their dawn raid to arrest most of these people in front of their families at their places of business. And you had the then Assistant Attorney General, Lanny Breuer, sort of making quips and headline quotes about what happens in Vegas doesn't stay in Vegas, which was the venue where the DOJ had manufactured all of the people would be arrested. So I think when you get to trial and you have a jury of citizens and they see that the government sat down at a conference table along with an admitted career criminal and drug addict and person who had a predilection for prostitution, of course Richard Bistrong, and they mapped this out and they orchestrated the defendants being in Las Vegas where they could orchestrate the arrest, after which the DOJ could orchestrate pictures and headlines in the New York Times and Washington Post and Wall Street Journal. I think it offends across the spectrum people who then look at the case. And And I think that's exactly what happened when you got to trial. And whether it's the O'Shea case or whether it's the judge calling out the DOJ, and more recently in the Seligman prosecution, these are judges who often, like Judge Leon, were appointed by during conservative Republican administrations to the district court bench. Judge Leon, as he calls himself, was a three-time recidivist, meaning I believe on 3 occasions he went back to DOJ as a criminal tax prosecutor. So the notion that these judges are somehow unfair to the Department of Justice is really a startling thing when you hear some of the prosecutors involved with these cases openly criticize the rulings of the court.
Another case you mentioned is the Siegelman case. This was in the summer of 2015, another unusual instance of an individual putting the DOJ to its burden of proof. What happened in that case is Mr. Siegelman was a former executive of Petro Tiger, was accused of bribing Colombian officials. The DOJ secured a guilty plea from Mr. Siegelman's attorney, also a former Petro Tiger executive who was supposed to be the star witness at trial. To make a long story short, the star witness acknowledged giving false testimony on the stand. The court, the judge in that matter, said, quote, "Did you have a hallucination?" The trial adjourned, and within 48 hours, the DOJ offered Mr. Siegelman a very, very lenient plea agreement that he accepted, and he was sentenced to no jail time. Now, the DOJ put out a press release announcing the guilty plea, and everything I just said, you would not have known if your only source of information was the DOJ press release. And you were very critical of that DOJ press release in the Siegelman case, calling it a silly press release that was offensive to the spirit of justice. Can you elaborate on perhaps that specific example and more broadly the PR that the DOJ often uses in connection with its FCPA enforcement program?
Well, I think the DOJ's Siegelman press release was a low watermark for the integrity of the Department of Justice. I mean, anybody and everybody who is either an attorney, a compliance professional, or a business person doing business abroad that follows FCPA enforcement actions knew, what a loss the Siegelman case and an embarrassment the Siegelman case was for DOJ, except, of course, DOJ, because in turning around and issuing a press release that touted essentially the walkaway, if you will, by DOJ as somehow a victory for the Department of Justice and its FCPA enforcement crusade, it was just really, I mean, there's nothing else to say other than that was an embarrassment for the Department of Justice to do that. If a company issued a public statement that was so devoid of accuracy and contained such material omissions as the Department of Justice did in that case, the company would subject itself to the potential for criminal prosecution for material misstatements, and so I think it puts a fine point on what the Department of Justice has proven itself beyond a reasonable doubt to be talented at doing. One, issuing press releases and coordinating those releases with the press for maximum exposure when the allegations are first announced, and two, trying at the back end to spin their losses in some way and lick their wounds to make it seem as if the failed efforts over often many years in these cases are actually not failed efforts, because the reality is DOJ can't seem to prove its cases in most of these instances.
Now, you mentioned something earlier regarding why so few FCPA cases go to trial, and you mentioned the fact that many FCPA lawyers are a lot of times former DOJ or even not so much DOJ, but SEC enforcement attorneys. I've used the term FCPA Inc. to broadly describe this space. A lot of people view that as a derogatory term, but it's merely a shorthand term to highlight the fact that really within a 5 to 7 year period, you've had a multi-billion, and it really is a billion-dollar niche industry, sort of grow up around this area. It's not just lawyers, of course. It's the accounting firms, the compliance firms, whatnot. So that's a little bit, as to the definition of FCPA Inc. But more to the point of what you were making, Washington, D.C. is very much really the epicenter of most of the FCPA attorneys. Of course, there's FCPA attorneys all over the country, but Washington, D.C. is very much the home to the FCPA practice. And what's interesting is when you look at many of these contested actions, the defense counsel are not Washington, D.C. lawyers. And that sort of raises the issue, and I'd be interested in your thoughts on this, whether in the FCPA context or perhaps more broadly, whether you think D.C. white-collar lawyers, perhaps because of their former backgrounds or connections, are perhaps too conciliatory towards the Department of Justice.
I think it's probably more of a former prosecutor mentality than a D.C. lawyer mentality that contributes to the facilitation of the culture of self-report, settle, and plea. The 5 co-defendants with whom we tried the Africa Sting case with in Washington for 5 months were the finest group of trial lawyers, and I think all of them were former federal prosecutors, but all of them were housed in and around the Beltway, and they were some of the most talented trial lawyers and probably the most talented group that I'd ever have the privilege to try a case with. The problem, I think, is not D.C. in terms of a conciliatory attitude. It's really the former prosecutor mentality. And I think a lot of the companies who wind up hiring FCPA Inc. are as much to blame for the continuity of this mentality and conciliatory relationship. I mean, when you think about it, if you find out you're under investigation and you turn around and you hire a lawyer who in a 20 or 25 or 15-year career has been in private defense practice for a year to 3 years, has never tried a case as a defense lawyer, has spent the last 10 years in management, often in the FCPA enforcement arena, and has not set foot in a courtroom other than to observe a trial. I think it's pretty obvious why a company would hire a lawyer like that, and I think it's pretty obvious that they're not hiring that lawyer to go to trial. And when you hire a lawyer who everybody knows is not going to trial, the DOJ knows that the target is not going to trial, and so it's a function of a lawyer coming out of a career in a culture of promoting plea and cooperation, now holding himself or herself out as a defense lawyer. And it's really difficult in my mind, and I think in others' minds, to believe that someone can overnight flip a switch and become oriented to the necessity and the art that is defending and trying a case. And so I think what you wind up with is, instances like I think I read on your website about Walmart's compliance and investigative fees approaching $800 million soon. And one wonders at the end of that whether Walmart will then turn around and open its checkbook and pay a similarly exorbitant fine to the Department of Justice, and whether there will be any indictments of the corporation or whether the corporation will get a pass.
Do you ever foresee this dynamic changing, and just in terms of relevant background? There's only been 2 instances, at least as I'm aware of, in FCPA history, where a corporation, as opposed to an individual, has put the DOJ to its burden of proof. One happened, back in the 1990s, when I think the risk-reward ratio for companies was, I think, materially different than today. The Lindsay Manufacturing case we talked about earlier, while that was more recent, that was really a unique circumstance in the sense that it was a small privately held company, and in addition to the company, 2 of its high-level executives were also charged. Do you ever see this dynamic changing? What would it take for Company A, Company B under FCPA scrutiny to do what sometimes people take for granted, and that's like force the DOJ or the SEC, even for that matter, to prove its case? Do you ever see that happening?
I continue to hold out hope that it'll happen. I think 2 key developments need to occur. One, you've often written and spoken about the need for there to be some sort of bar or moratorium or prohibition on prosecutors leaving the FCPA group working on or having clients who are under FCPA scrutiny. I mean, let's face it, when the revolving door stops after a series of exits from the fraud division, and those FCPA prosecutors have landed at the big law firms inside the Beltway, it seems like, for them to then on a Friday leave the department and on a Monday be representing somebody who's been under investigation for a period of time, that raises some concerns. So I think it would be a welcome. I think it would be a welcome prohibition if folks who left, were unable for a year or 2 years to handle FCPA matters, or something less. If it's a new FCPA investigation that arose after the departure, that's perhaps a different ballgame. But the second thing is, I think companies are going to have to get educated, and the compliance personnel are going to have to get educated on the fact that the notion that there's a track, and that the track is that they have to plead, cooperate, and present all the information they find, no matter how marginal, to the Department of Justice is not the singular track, and often it may not be the best track. Every case obviously is different and unique, but the mindset that companies have to hire a Washington, D.C.-based Beltway firm with 500 to 1,000 lawyers and a white-collar group that has, former federal prosecutors that worked in a fraud section, the proof is in the pudding as far as what the outcome is going to be for that company. So, there needs to be a little righteous indignation and education. I remember being at a panel with Jan Hanslick, who represented Lindsay and its principal, probably within 6 months after the Africa Sting victories and the Lindsay victories. And in the audience were a series of high-level in-house counsel and compliance personnel and other executives for some of the world's largest aerospace, military, and pharmaceutical companies. And these are folks who have been involved with pretty sophisticated internal investigations on other areas of the law, and they know how these things work. And when they heard the truth about the DOJ's conduct in these investigations, there was some righteous indignation from the executives and compliance and legal personnel for the companies, including, some pretty brash statements about how they would react if their company was ever subjected to that kind of abuse and playing fast and loose during the investigation and prosecution by the government. So for that reason, I hold out hope that that the thing can be turned around, and we'll get back to where we're supposed to be, which is, holding the government to its burden of proof, and win, lose, or draw, the system works as it's supposed to. The system's not supposed to work on a cozy relationship between the defense bar and the government that results 90% of the time or more in cooperation and plea agreements that don't afford any transparency or guidance for future companies that are under investigation.
Well, there's no doubt about it. There's different dynamics at play when it comes to corporate enforcement versus individual enforcement of the FCPA or any law for that matter. I do think if more corporations, business organizations, what have you, would put the DOJ to its burden of proof, I am fairly confident that this entire landscape would look a little bit differently than it does now. So thank you, Paul, for joining us on this episode of FCPA Flash. I thank you very much. And, my final thoughts are this. I would never wish federal criminal charges upon anyone, but if an individual does find themselves in such a position, they deserve a zealous advocate, a lawyer who's going to work hard and force the DOJ to prove its case. And from my perspective, you're one of the best at doing this, and it's my pleasure to have you on this podcast.
Thank you for your kind words, Professor. Keep up the good work.
Thank you.